What makes up the judiciary? This is the court itself. We talked about the actual different court systems. Now we're going to talk about the specific players, so to speak. We have the judge. The judge is in federal court or in state court. The judge is the kind of the overseer of the court, and we're going to be very, very general. The New York court system itself is overseen by one senior judge who does not go to court and sit on the bench and hear cases. The judge oversees the court system as a whole throughout the state. And actually, there's a few of them in each judicial district around the state. There's 6. And then the judges are broken down per their duties or what they are elected or appointed to do. So a judge, generally speaking, a judge sits in federal court, a judge sits in state court. We could have a court of general jurisdiction that oversees everything, including criminal cases, or like in New York, we just have a specific court for felony cases. Either way, if we're talking about a criminal case, there's a judge. A judge is involved and is overseeing the case. It's their job to move it along, to stay within the required time frames. You may be familiar with the term speedy trial. That is a constitutional right. The judge is the keeper of the time, so to speak. If there is a trial, and there's a jury trial, the judge oversees it. I'd like to refer to the judge as the referee. That's what they do. They oversee the proceeding. They make sure the correct information, not the correct information, but they make sure that the attorneys play by the rules of the court and the rules of the evidence to make sure that the defendant's rights are not violated. And their primary role in a jury trial is to instruct the jury of the law. The jury is listening to all the facts in the case. It is the judge to advise them what the law is, and then the jury applies the facts to the law and to make its decision. If there's no jury involved, because the defendant does have a right to waive it, and the judge will oversee the trial. It's called a bench trial, and that has to be waived in open court of the constitutional right to a jury. And sometimes they do. High-profile cases where it might be hard to get a impartial jury. Complicated issue. There's a complicated issue involved that is probably more so for a judge. It happens. It's rare, but it happens. If the defendant is found guilty, the judge is the one that hands down the punishment or the sentence in a criminal case. The court has numerous staff in and of itself. There's a court clerk who sits in the courtroom and takes notes. That's different from the court reporter or the transcriptionist, who's also a player in the court system. That's the person who takes down the record, what's happening, the testimony. There's court administration that oversees the overall make sure files are in order, they get the right files to the court, the right paperwork is where it has to be. The administration. There's court officers, or bailiffs as they call them too, who protect the court system and the court staff, very much like they are actually considered a law enforcement agent. There are law clerks. Law clerks answer to the judges. They help them do research with a particular issue. While the judge is on the bench, an issue might come up, and he might ask his law clerk to, research this issue or help draft a decision that he or she is writing relative to an issue in the case. And there's also staff that monitor and assist and kind of get the jury moving along of where they have to be from point A to point B, filling out paperwork and that sort. So there is a lot of staff involved in the court system. Now you see on the screen that, judges have control, it should say, and or influences other court agencies. They don't necessarily have control over them as more so as influencing these agencies, aside from the clerk of the court. But if we're dealing, all of these players have to come into court: probation, police, district attorney. They all have to come in and present to a court and look for guidance from the court, or look for the court to make some sort of decision relative to what's going on. With probation, the court, as I said, the judge has got the job of sentencing a defendant. If they sentence the defendant to probation, probation has to report to the judge how the person's doing. If they're not doing what they're supposed to be doing, then they have to go back to court for a hearing. The police file the paperwork with a court, with the exception of matters that have to go before a grand jury. We already talked about the grand jury. But law enforcement plays a role. They have to come, they have to testify. And the district attorney. The court does not have control over the district attorney. The district attorney, as we'll talk about in a little bit, has the complete control over charges, but the judge is the one that guides the case along. So a district attorney is a player in the court system, as well as defense counsel, which we will get to momentarily. But all of these agencies have some sort of influence, or are influenced by the court, or in some instances influence the court. All right. Cool things. I've already discussed some of these qualification requirements, so I'm just going to kind of buzz through the information here. I think I pointed out when we were talking about the Supreme Court that a judge's attitude and philosophy has a major impact on the justice system. It sure does. If we're talking about a Supreme Court, if it's more conservative points of views, you're going to end up with more conservative decisions. So certainly that plays a role. It also will affect police policies and district attorney's offices too, because if a district attorney wants to bring a case and they know how the judge feels about a particular type of case, that may persuade them to take different action, or if they know that the judge hands down harsh penalties in drug cases, they might push those a little bit more, and the police are more apt to make certain arrests in certain areas. It's certainly, knowing what the court, or i.e. the judge, is going to do, does have a major impact on decisions that get made by counsel when determining how to move forward in a case. For instance, I'm going to give you a real world example. If there was cases that involved theft of money or welfare fraud, where money was owed to the system, or somebody stole from their employer, there was a judge, long since retired now. But if that was replaced, if that was made whole, the person was made whole by the defendant, they paid back the money, whatever, or they fixed the damaged, property, and took responsibility, the judge was more lenient on them. But the same judge was extremely harsh in driving while intoxicated cases. He was a firm believer that you don't drink and drive. And if a case like that came before him, he was a little bit more harsher. So, those things exist out there. We already talked about the qualifications for the federal judge. I won't stay there, but we'll talk about state qualifications. It's going to vary from court to court. In some states, Connecticut for one, judges are appointed by an attorney general, by the governor. Sorry, not the attorney general, the governor. Judges are appointed. In others, it's an election. New York State, we elect our judges. There in the federal court system, there's non-existent qualifications to become a federal judge, but in state court, generally there are at least a few requirements that the judge has to reside in the county or the state, depending on the type of judgeship. They have to be licensed to practice law in that state. In New York State, you can't be a Supreme Court justice unless you've practiced for 10 years and have a law degree. In state court, you can't serve as a judge once you are 70. If you have been elected to the position of judge before your term ends, you turn 70, you must retire. 70 is the cap-off age. There is no requirement in federal court. You might be familiar with, if you live in upstate New York, the local court system or the justice courts. Each town and village has their own court that handles small crime matters like misdemeanors and violations and traffics. Those justices that sit in those courts are elected by popular election for that town. Only the people in the town can vote for that position. And there are no qualifications except that you reside in the town that you're running in and want the position in. You don't even have to be a lawyer. You have to have a law degree. You don't even have to have any sort of level of education to have one of those positions. And without a doubt, over the years and decades, that kind of it's kind of been under attack and under review, and they are reviewed. They have a judge that they must answer to, that they're assigned to answer to, and even the Attorney General reviews what happens in those courts because of that. So, all right, let's move on. I don't know why I like to describe the court, this arena that we're talking about, as a ballpark. Like, I think of the court as a ballpark, the judge is the referee, and the players are the prosecutor and the defense attorney. It makes sense in my head in the simplest of form. But anyway, we're going to talk about player one, the prosecutor. Now, there is a video that's in the supplement additional materials on Moodle. 15 minutes long, I think it is. It's about a prosecutor and his view of what needs to change in the criminal justice system from a prosecutor's point of view. I suggest you watch it before you get to this, because I think this content will make more sense hearing it come from a prosecutor. And then you can understand their position and how powerful their position actually is. So, the prosecutor represents the public in criminal cases, and their jurisdiction spans the entire justice process. They have, it's their job to prosecute crimes against society. They're also described as the chief law enforcement officer. The district attorney is the chief law enforcement officer. They are referred to as district attorneys. In New York State, they're called district attorneys. In the state of Vermont, they're called state's attorneys. At the federal level, they're called the U.S. attorney, also referred to as the government or the people or the prosecutor. They have various names, but their formal titles, are district attorney, state's attorney, and U.S. attorney. And they are the most powerful person in the game. Why do I say that? I ask, what is their role? They investigate cases, not just law enforcement. They investigate cases before and after an arrest. They can certainly be involved. They prepare the legal documents, sometimes even the charges. They participate in obtaining search warrants or arrest warrants. just like law enforcement. Sometimes they help law enforcement. Sometimes there's warrants law enforcement can't get that the prosecutor can only get, such as cell phone records. Prosecutor wants cell phone records from a specific individual. They would be the ones to have to retrieve that information. They decide whether to charge a suspect or not, and if so, what offense. And they can change it. Even if, an officer decides to charge a particular assault level, let's say, they can change it. The DA can say, no, that's not enough. We don't have enough evidence to do that. We might a lesser charge or a worse charge. And they can also direct the officer, don't charge that, charge this. They are the ultimate decider of the charges that they're going to pursue against somebody, because they are the prosecutor. So for example, an assault can become an attempted murder if the prosecutor feels that they can prove the case beyond a reasonable doubt. That's what they'll do. Also, it's their job in a criminal case that if they have to proceed through grand jury, i.e. felonies have to go through grand jury, they have to bring all the charges that they possibly can bring. Otherwise, they lose that opportunity. If there's a not guilty plea, they can't go back and say, oh, but we could have got this lesser one, so let's try that one. They can't do that. So they have to bring it all. So in the example I just gave, if they went to grand jury, they would have to present their case as an attempted murder and an assault. And at trial, it would be up to the jury to decide based on the facts whether we have an attempted murder or we have just an assault. And it turns on the elements of the crime, which is a little beyond the scope of this discussion. What else do? They give advice to law enforcement when necessary. They represent the state in plea negotiations. Do they have to? Nope. There's no such thing as a constitutional right as a plea deal, plea negotiation. That is completely at the discretion of the prosecutor. And about 95%, it's closer to 98% in federal court, cases end in a plea deal, even though they're not required to give them. The reasoning behind this is judicial economy. If they tried every single case, that would cost the governments a lot of money. And overall, they take the case from beginning to end. Once it hits court and there's arrest made from arraignment all the way up through the end of the appeals process. That's what the prosecutor does. So let's talk about the types of prosecutors. The federal court, as I said, U.S. attorney. They're appointed by the head U.S. attorney is appointed by the president. So each state has a appointed, depending on their area. In New York, there's 4, the northern New York district, the southern, the western, and the eastern. And each one of those districts has an appointed U.S. attorney. And then that U.S. attorney hires assistant U.S. attorneys to help prosecute cases. The head person who prosecutes not only criminal cases, the Attorney General has a number of divisions inside it that it handles cases, but one of their divisions is criminal, and the Attorney General will handle things at a state level. And then at the county level, we have district attorneys, and then they have assistant district attorneys. The Attorney General has assistant attorney generals. The Attorney General in New York is elected, as are the district attorneys from county to county. All right, where do we go here? So, practices, structures, the political atmosphere, all of these things play a role. I thought I skipped something, but I didn't. So, white-collar crime. These can handle a whole bunch of arenas. These are the, white-collar crime. There's drug possession, trafficking, corruption. You see a lot, and computer crimes, terrorism, those are for the feds. Computer crimes, terrorism, the federal U.S. attorney primarily prosecutes those. They also prosecute some white-collar crime and some serious drug trafficking. It has to be intrastate. The Attorney General, I have seen, bring its own cases for drug trafficking within the state if it's too big for the county. This happens I guess it's still in northern New York. If you're thinking, for those of you who might be from St. Lawrence County, Franklin County, over the last couple of years, there have been big drug busts with well over 100 people per bust, and these involve people from all over the state trafficking their drugs around, and the Attorney General steps in. That is something that is, because it goes from county to county. It's not just restricted to one county, so the Attorney General steps in. And then the district attorney handles those things within its county. But there's a whole wide range of crimes that they prosecute. Discretion, kind of like the police. The prosecutor has discretion. And this is a concept that is really brought out in the video from the prosecutor. He explains in such detail about how much, with examples of how much control the prosecutor has. The prosecutor is the primary. If the police have discretion, the prosecutor has more. The prosecutor gets to decide whether to bring a case to trial or to dismiss it outright. The prosecutor gets to decide to pursue a case now, and he can pursue it and then later just decide not to, or drop it, or ask the court to dismiss it. They can seek a review of a case through the preliminary hearing stage or the grand jury stage to determine if there's enough evidence to pursue a case, to find out if they need more. As I said earlier, in Section 1, if it's a felony in New York, you have to proceed by grand jury. They decide whether or not the plea offer should be given to a defendant, and they decide the terms. You might think it's negotiated, but most of the time it's, here it is, take it or leave it. And then some things can be negotiated or worked out, but for the most part, the prosecutor controls the plea bargaining stage. And the reason behind it is because there's no right to a plea bargain. They don't have to. And in a lot of their cases involving children, sexual assault against children, they will look for the top count, a plea to the top count charge, when I say top count, the charge with the harshest penalty against it, and want to plea to that with nearly the max penalty. And a number of times it's backed by, they have a lot of other charges that they can bring, and hence the sentence becomes stacked, which means more time for the defendant. But in some cases, they take some pretty harsh stance. DWI is a very harsh stance. Our prosecutor here in Clinton County stands by. So I will note that with lower level offenses or minor offenses, it depends on the county. A prosecutor may take a limited role. That's usually if we're dealing with violation levels or lower level misdemeanors. Our misdemeanors in New York, we have an A and a B, so B is a little lower. Sometimes they will leave those to the police to resolve, or to the claimant itself. If there's a harassment or a disorderly conduct, the person making the claim would have to go to court and prosecute on their own. Traffic offenses used to be primarily law enforcement. The prosecutor's involved with those now through a certain written policy. They don't go to court and try them, though. That would be the law officer. But I'm digressing. All right. Factors that influence the prosecutor's discretion. Very similar to police officers. Legal issues. How serious is the crime? The strength of the evidence. That's how it's going to be determined. They have to determine if the evidence was collected legally or not legally. If they have to conduct the hearing on an issue of whether or not the police were involved in an illegal search and seizure or failed to give Miranda warnings to the defendant. That is something that would be brought to the court for a hearing, and the judge would make the ultimate decision, but it's the prosecutor that has to show beyond a reasonable doubt that the police acted accordingly. Victims' issues, whether the victim cooperates, and as they say, press charges. This is a little sticky subject, victim issues. If you've got an actual victim, a person, it's an assault case or a domestic violence type case, or somebody stole something from somebody and you actually got a person, they have to come and testify if there was a hearing. And sometimes it turns on their cooperation, but the district attorney has ways to make somebody cooperate, meaning if a victim went through all of the steps to call 911 or get the police involved, to make a statement, especially if it's a written statement, and then the prosecutor now is involved and there's going to be a trial, and now the victim like, oh, I don't want to do a trial. The prosecutor can say, but you wrote this statement and you signed it, so we can just subpoena you and you'd have to come. Either you work with us and I can help you through the process, or you're going to have to just come and take the stand and see what happens. So there's, victim, and of course they do take into consideration where that cooperation or now non-cooperation is coming from, because sometimes victims are influenced by the defendant, or they're getting cold feet, especially in domestic violence cases. They don't want to rock the boat. Which brings me to pressing charges. Victim calls 911. There's a domestic violence incident. The police come. They charge the aggressor. And then 2 days later, the victim calls the prosecutor and says, I want to drop the charges. That's no such thing. That does not exist. Once charges are brought, that's completely up to the prosecutor to decide. And yes, people have dragged their feet about wanting to cooperate, but believe me, the prosecutor will use its subpoena power to bring in a victim to assist. But it does play a role. If it's a low-level crime and the victim is just hemming and hawing, the prosecutor will sometimes just dismiss the case. But it's not always up to the victim, but it's something that they consider. Extralegal issues, the offender's race, gender, ethnic background. Due process says this has no bearing. The prosecutor cannot use any of those things. Due process. We have this thing of due process. Could it play a role? What about the victim's race, gender, or ethnic background? Does this influence a prosecutor's discretion? It's really a hard thing to prove. Obviously, it's even really hard to prove when there's this constitutional protection. So, where am I going? All right. So issues in plea. I want to bring that up relative to issues in plea deals, right? Issues in plea deals. And I'm not going to charge a woman who had sex with an underage boy, but I'll charge a man who had sex with an underage girl. The gender issue, right? I'm not going to charge a white drug dealer over an African American drug dealer. Do these have bearings? We've certainly seen it relative to sentencing. However, when we get to sentencing and court sentencing options, I've seen plea deals where women in that situation are given a more favorable plea than a man. I have seen it. There is a prosecutor that actually was a prosecutor. She went over to Vermont now. There was a prosecutor who handled all the sex crimes here in Clinton County. She was an affirmative, no, I don't treat people differently. You can tell me whatever you want to tell me about your client, the defendant, but I am certainly not going to say because this person was a woman, she should be treated any differently than if it was a man. And she was pretty affirmative, and that's a good attitude to have. I digress. All right. I forgot one more. Resource issues. Available treatment. Think about these things. There's lots of cases, so the caseload of the prosecutor is quite hefty. They don't, as I say, prosecute violation crimes most of the time. It's very costly to have trials, so they give out more lenient plea deals for the lesser violent crimes, or agree if there's treatment available, agree to treatment options. So they're looking at resource issues too. This is probably the factor that affects discretion the most, along with government budgets. That's another thing that affects them, and the laws change. Recently, New York State had the bail laws have changed. We'll talk about those in the next chapter, along with the discovery rules, which is the requirement that the prosecutor has to turn over evidence to the defense counsel. It's a little bit more lax, which has now made their job not harder, but it's more involved, and that will influence plea deals coming down the pike, as we'll find out, because those laws just went into effect beginning of the year. So is discretion a good thing? Now, hopefully you've watched that video and heard from a prosecutor himself. Is discretion a good thing? What if they had none? What if everything that came in had to be prosecuted from beginning to end? Is there too much? Would it lead to abuse? A lot of these are political positions. They lose too many cases. They lose election. They don't look like a hardcore person, hard on crime. Things to consider about discretion. What about ethics? Pros and cons, discretion, ethics. I may have skipped a slide. I did. So let's talk about pros and cons. Actually, I think I already talked about pros and cons, right? I'll let you read throughout this big, with discretion, without discretion leads to abuse. Too many cases become unmanageable, though, if you don't have it. Skip to ethics. Their job, their obligation is to seek justice, not to seek a conviction at all costs. They seem to mess that up a little bit. And some do things that are unethical. What happens if they do that? Like, here's some examples. They don't turn over evidence when they're supposed to, or they mislead or misrepresent the evidence. They might influence the jury improperly. So their obligation is to seek justice, despite the need for convictions. There's not a lot of punishment that a prosecutor faces. I told you about immunity in law enforcement. Prosecutors have immunity, and it's even a higher level than law enforcement. So it's very hard for them to be punished for their actions. If any of those things that I just talked about happens, what do you think happens? It gets reviewed on appeal, and the case gets overturned, and then there's a new trial. If they are caught doing something that I just described at trial or during a proceeding, the punishment is the court may not allow that evidence in, or they may just call it mistrial and it has to start all over again. So, nothing happens to the prosecutor. There's this concept of prosecutorial misconduct. This is when they behave with their vindictiveness, and it's when it's obvious. It has to be obvious. When it is obvious, the court will prevent it from happening. But still, there's no punishment. There's no fine. There's no suspension of license. They're not even required to have to take an ethics course when this happens. All this does is either result in a new trial or sometimes a dismissed trial, or the failure, or the judge refuses to let them bring in evidence that they were hiding, if it was that concept. So nothing happens to them. So they have to be really on the ethic, moral compass radar. And that finishes up my discussion of the judge and the prosecutor. Our next player is going to be the defense attorney, and we'll talk about court administration to finish it up.